Good day, and welcome to today's 3E's of Legal Email Management conference call. Today's call is being recorded. Now, I'd like to turn the conference over to Kelly Winter. Please go ahead.
Thank you. Good afternoon. I'd like to welcome everyone to part 2 of our 3E's of Legal webinar series with our distinguished partner, Axyon Consulting. During this presentation, we'll discuss the different approaches that organizations should take to manage email content as business records, and building on the e-discovery concept introduced in part 1 of this webinar series, we will more granularly explore the requirements and challenges associated with deploying email management. We're pleased to welcome back many of you from previous events as well as the newcomers in our audience today. We're just about ready to start. If you have a question for one of our presenters today, please press the Q&A tab at the top of your screen to open the question and answer panel. We will do our best to answer questions if time permits. As always, we thank you for your time and look forward to presenting to you today. At this time, I'd like to introduce our speakers for today's presentation. Darren Harrington is an attorney and shareholder with Barnes & Harrington, P.C. His principal area of practice is focused on representing local, national, and international corporations and their officers in cases involving labor, personnel, and government regulatory matters. He is regularly called upon by employers to defend against claims under the various anti-discrimination and employment statutes and numerous other matters involving employment and traditional labor law. We also have with us Curtis Price. Curtis is the chief architect and co-founder of Axyon Consulting. He has held such titles as Manager of Corporate Infrastructure Systems, Engineering Professional Services Project Manager, Professional Services Consultant, and Director of MIS. Curtis's business experience spans the energy, real estate, professional services, and municipalities markets. In one of his most significant successes, Curtis led the migration of a 900-user network to an outsourced data center. His planning and direction resulted in 0% system downtime. And finally, we have Jeremy Barnes with us today. Jeremy is the Program Manager for Email Management with OpenText. Jeremy holds worldwide responsibility for OpenText's email management business, including business planning, go-to-market execution, and product strategy. He has been with OpenText for 7 years with a particular focus on records management compliance and e-discovery. I'd just like to quickly go over the agenda for today. We just went through the introduction. I'll be handing it over to Darren Harrington to discuss a little bit about harassment claims. And then Curtis Price will be going through managing email successfully and popular methodologies. And finally, Jeremy will wrap up with a demonstration of the email management solution from OpenText. So at this time, I'd like to turn it over to Darren. Darren, please go ahead.
Thank you, and good afternoon to everybody who's participating. I do appreciate the opportunity to come and address you on this issue. It's an interesting issue. Sexual harassment is, and has been for some time now, an interesting issue, I think, for people in human resources, operations, etc. It is and continues to be an ongoing problem for many employers. And I think what makes today's topic even a little bit more interesting is that we're talking about how electronic communications, and probably most specifically emails, affect an employer's exposure to liability in this particular sexual harassment realm. There are some unique challenges, and as the case law has developed over the last 10, 15 years, as email has become more prevalent, employers are starting to find a little bit more direction in terms of what they can do to help minimize their exposure to liability. I think we'll all agree that today, in performing their jobs, American workers have grown heavily dependent upon accessing the internet, email, instant messaging, or IM, texting, and other forms of electronic communications. I myself am a little bit of a technological idiot. I'll have to admit that up front. But even I use a number of these things now on a regular basis. And they are, for the most part, very beneficial, I think we would all agree, to our ability to be productive and accomplish our jobs. But there is, of course, as with most things, a downside. And one of the downsides is that these communications can provide a work environment that is detrimental to the company. It can provide a hostile work environment. It can provide a sexually charged work environment. For some reason, people look at electronic communications particular emails is something different, something less permanent, something that is not as significant as normal communications, either verbal or even memorandum, etc., that are actually reduced to paper. Now, having said all of that, we are now starting to find out that, and have for, I guess, the last 4, 5, 6 years, that this type of communication is adding whole new wrinkles to the discovery process in a lawsuit. Used to, it was relatively straightforward. If you were the plaintiff, you would issue a request to the defendant, the company, and say, these are all the documents we want. You would battle over what you were going to give them, and then you go provide those documents. But because so much now is done electronically, responding to that request has actually become quite complex. And many plaintiffs' lawyers, very sharp, creative plaintiffs' lawyers, are learning to use the e-discovery process, the electronic discovery process, as a powerful weapon to gain leverage over a company, both in mediation, settlement negotiations, and even in trial. And certainly sexual harassment claims are an area where this type of strategy is being used rampantly. Now, for whatever reason, I'm not a social scientist. I can't tell you why people look at electronic communications as being something less. People tend to be more cavalier, more casual in these communications. Sometimes their humor can be edgier. Email jokes that are racy or provocative get circulated pretty quickly. I guess you only really have to push a forward button. You don't actually have to tell the joke yourself. You don't actually have to take the photograph out into the public, hold it in your hand, and show it to somebody. And maybe because of that, there's not the same social barrier that we're accustomed to. And so even somebody who is normally fairly reserved can send provocative, racy-type communications that they would never otherwise do. The problem, of course, is that this creates an environment potentially that is hostile and sexually charged. Or what often happens is you may have an instance of, say, sexual harassment, and then a plaintiff's lawyer will look at all of the emails and things that have been circulated during that time frame and use the emails themselves as a way to provide context. Well, maybe the emails themselves don't go directly to the specific conduct, but certainly look at the atmosphere that's being created. Look what people are passing to one another. Look how permissive the environment has become in regards to these type of topics, these subjects, these communications. Pornographic photos, racy jokes, crude jokes are commonplace in this environment. Is a charge that might be lodged because you have these